Hello, my name is Tim McCurdy, and I am a guardianship lawyer practicing in St. Louis, Missouri. Today we're going to be talking about physicians' interrogatories and their role in the guardianship process. Guardianship is when the court determines that someone is incapacitated and needs to have someone else manage their affairs. Incapacitated means that someone lacks the ability to make decisions for themselves or is unable to communicate those decisions regarding where they're going to live or where they're going to go see the doctor, such that they are at risk of serious harm. Conservator is someone who is appointed to manage the finances for a person who lacks the ability to do that. For a conservator, the person is found to be disabled, which means they lack the ability to manage their finances. And the question becomes, who decides? Are you incapacitated for a guardianship? Are you disabled for a conservatorship, which are similar findings, but there has to be evidence for the court to determine that an individual meets these legal definitions and that someone needs to be appointed. And to do this, the court is going to consider medical evidence, evidence from a physician or a psychiatrist who is going to provide testimony to the court saying whether they believe that the individual is incapacitated or disabled, or perhaps they're partially incapacitated or partially disabled. And there are two ways that the court receives this information. One can be a medical examination. The court has the authority to order the individual to be examined by a physician who is identified by the court, and then that physician or psychiatrist will report back to the court their findings on whether the physician believes the person is incapacitated or disabled. The other way that this is done, and the most common way that a guardianship is pursued, is with the use of what we call physicians' interrogatories. Physicians' interrogatories are forms that are completed by a physician or a psychiatrist indicating his or her opinion regarding the individual. And this is something that will be done when you have a physician or psychiatrist who has examined the person fairly recently. They're able to express a medical opinion based upon their examination of the person, where they're identifying the findings of that examination. They are indicating their opinion or their diagnosis of that person and whether or not they believe the person is in need of the guardianship or the conservatorship. After the physician has completed the examination, then they're going to complete this form that we refer to as the physician's interrogatories. And in our video today, we're going to be walking through one of those forms so that you can see the issues that are being decided both by the court, the evidence that they want from these physicians, but also questions that you're going to ask of the physician. Because the important thing to remember is that the court is only going to find a guardianship or conservatorship necessary if the court finds that the person is in fact disabled or incapacitated. So if you don't have this, if you don't have a physician who has seen the patient recently and is willing to offer this opinion testimony through these interrogatories, then it's going to make it very difficult to obtain guardianship. So we are looking now at the physician's answers to interrogatories form that is provided by the St. Louis County Probate Court. And it's something to keep in mind when you're completing any guardianship application is whether or not you're filing in a county that has approved forms. And in the city of St. Louis, in St. Louis County, in Jackson County, in Kansas City, St. Charles, the different probate courts will have their own forms, and if that's available, you'll want to use those because it's something that the clerk will be used to seeing. You know that it's going to meet the requirements. And then it's also something to consider if you're in a county that doesn't have those forms. It's a good starting point as you're preparing these documents. But for the physician's answers to interrogatories, this is something that is going to be provided by the physician or by the psychiatrist. So it's actually not being completed by you or your attorney, although you can certainly seek out the physician to provide these answers and even offer whatever help you need to. But as we look at the form, we have the style of the case, and then you're identifying the physician. And first it's going to ask about the physician's qualifications. Why is the physician able to offer this expert opinion? They may just attach a copy of their resume, what they will call a curriculum vitae, that will show where they went to school, that they're a licensed physician, they're a licensed psychiatrist, what have you. Just that they have the educational background, the experience to offer these opinions. And then the next question is going to be to learn how recently the physician has examined the patient. So there isn't a set rule in terms of recency, but obviously the further out you get from the time when the physician has seen the patient, then the less likely that the court is to give reliance to that. So you'll want this to be as recent as possible, say within a few months at least, to be able to say that the physician has seen the patient. They're able to say what their current diagnosis is. And then the physician is asked to identify the diagnosis of the patient with specific references to the DSM, because that's something that the court is going to be familiar with. And then a list of the medications that the individual is taking. And sometimes you'll see the physician is just attaching a copy of the medical record that will have this information. And then we get into interrogatory number 4, that is really the heart of the question for guardianship. Is the respondent an incapacitated person in that he or she is unable to receive and evaluate information or to communicate? And we're just going to get the highlight here. So is the respondent an incapacitated person in that he or she is unable to receive and evaluate information or to communicate decisions to such an extent that he or she lacks the capacity to meet the essential requirements for food, clothing, shelter, safety, or other care, such that serious physical injury, illness, or disease is likely to occur? So this is straight from the statute. This is the standard to say that someone is incapacitated for a guardianship. And the physician will give their answer, and if it's in support of the petition, it will say yes. Now, at the bottom, it makes clear that it's not enough for the physician to simply say that they may benefit from a guardian, or a guardian may be helpful. Here, they must definitively say that the person is unable to receive and evaluate information or communicate their decisions to such an extent that they are at risk of physical harm. And it makes very clear anything short of that is insufficient. And then here we have the standard for the conservatorship. Is the respondent a disabled person in that he or she is unable to receive and evaluate information or communicate decisions to such an extent that he or she lacks the ability to manage his or her financial resources? So you see, you have less instruction, less of a more detailed definition for the financial side of it, but the focus being, can they manage their own affairs? And then again, they have this language at the bottom where it says it must be a yes, or yes, and it's a partial, but it is not sufficient to say they may benefit from a conservator, or it'd be helpful or advisable. The doctor must give this opinion. And, of course, if they don't believe it, then they won't give that opinion and they won't support the petition. And then they say, if the answer is yes, what physical, mental, or cognitive condition is the reason for this incapacity? So that will refer back to where they had given the diagnosis before. And just the comment that there must be a connection between the diagnosis and the incapacity. And then they give an example of for Alzheimer's, it prevents the person from being able to remember, take medications on time, things like that. Interrogatory number 5, does the respondent have the capacity to participate in the voting process? This is something that's specifically asked because on the guardianship petition it asks, are they able to vote? Because that's a significant right that someone has that the court is going to specifically consider, do they have the ability to continue to vote? Also, does the respondent have the capacity to drive a motor vehicle? Do they have a driver's license? And this is one where, again, it's a significant limitation to say that someone can no longer drive. They want to know whether or not they're able to do that in the physician's understanding. Does the respondent have the ability to understand and enter into a marriage? That's something where, if you have someone who has some form of a mental disability, then the court needs to know, is this someone who is able to understand and get married? And then the court will be making a finding if they determine that a guardianship is necessary. The legal standard is what is the least restrictive alternative for the individual. And they give examples of a skilled nursing facility, intermediate care facility, residential care facility, group home, assisted living, to say, okay, where can this person live and function in the least restrictive alternative, but one where they're going to be safe. Some people simply, can't live in a group home. They have to be in a nursing home because of their condition. That's what the court is asking here. And then in which the respondent must presently be restrained in order to prevent the respondent from injuring himself or others, and or to provide with such care, habilitation, treatment as are appropriate considering their physical, mental, and cognitive condition. So this is the physician giving an opinion. I believe the person needs to be in a nursing home. I believe this person can live in a group home. This person can live independently, but they still need a guardian, things like that. And then finally, you'll have a concern for the, privacy rules, HIPAA. For physicians, they're going to be concerned about, I'm sharing this information about my patient, and the court is just making sure that the physician is protected to know that they're able to complete this form under the court process. And that would be the interrogatory. It's signed by a physician and then notarized for the physician. Now, as you can imagine, it can be difficult to get a busy physician to complete this form. You may need to help participate in it, make sure that this takes place, because this is a very important part of the guardianship process. And if you're not able to obtain this, then it's going to be very difficult to pursue the guardianship process successfully. I hope you found this information to be useful. Please keep in mind that this is general information and it is not intended to be used to make decisions about your own unique legal needs. If you have questions and want to learn more about guardianship or to discuss your specific case, I'd be happy to answer any questions that I can. Thanks again.